justice, and truth, and that shall be heard. Long live the king. Ready? You may be seated.
Good morning, all.
Good morning.
Morning.
Good morning. Morning, Your Honor. Good morning, Professor Messamore.
Good morning.
Your Honor, on a point of housekeeping, a second volume of Ontario's Compendium for the Cross-Examination of Barbara Messamore has been provided to all the parties electronically and in hard copy today.
Thank you.
I propose, with, I believe, the consent of my friends, that this be marked as Z2 and that yesterday's be changed to Z1 for identification.
Beautiful. Is everyone content with that?
Yes.
Thank you. Let's actually see. Can I?
All right.
Let me just set myself over here. Thank you.
Professor Messamore, we are still going to be working with volume 1 that you received yesterday.
All right.
So if you have that in front of you, and then of course your report and your demonstrative slide deck, that would be helpful for this morning.
Yes.
And yesterday when we finished for the day, we had been talking about Ontario's position that it was not responsible for augmented annuities. And we ended the day with the Mowat letter of 1874. Do you recall that?
Yes, I do.
Could I raise a housekeeping thing with you, Ms. Barkley? Do you mind? I know from time to time you say, oh, entering into a new section, or we're doing this or that. If you have in mind some subtitle for that section, I would also use that.
Okay.
It would help me in my notes.
So I'm certainly happy to do that. I would suggest that this subtitle that I'm starting with today and that which I ended yesterday could be called Ontario's view respecting liability for increased annuities.
Thank you.
Okay. So continuing on that subtitle, if I may call it that, and in particular, Ontario's view that it was not responsible, I wanted to take you to the meeting that was held in October 1884 in Ottawa. Okay. You talk about that in part on slide 171 of your demonstrative. It might help you to look at that to refresh your memory about it.
Yes, I will. Slide 171 is about Mowat's response to the claims.
My mistake. I even have that different. Okay. My friend is telling me that it might be helpful to turn to page 137 of your report. And there's a heading there, 21-22, October 1884, meeting between representatives of Ontario, Quebec, and the Dominion. Do you see that?
On page 140. In family report, yes, I do.
Okay. So it's this meeting that I wish to discuss with you.
Okay.
Okay. I understand that this meeting was held in the context of the discussions that we had yesterday. And it was in the context of the Courtney, the Deputy Minister Courtney redoing the accounts on the request of Ontario and Quebec.
Yes, I believe that's right.
Okay, thank you. So that's good that we agree on that. I wanted to take you through this document, which I understand to essentially be an meeting minutes and then a transcript from those meetings. Is that your understanding as well? If you could look at the tab 9 in our compendium, starting at page 107.
Tab 9. Yes, it says it's a memorandum of the meeting.
And then we see on page 107, there's a number of people present. Can you tell us who these people were at this meeting?
Samuel Leonard Tilley was the Dominion Minister of Finance.
Yes,
A.M. Ross was the Treasurer of Ontario. J.G. Robertson was the Treasurer of Quebec. J.M. Courtney was the Deputy Minister of Finance for Canada. So G.H. Sproul, is that G.H.? I'm not sure, it might be C.H. I can't remember his first name, was the Auditor of Ontario. Lawrence Van Coonet, or L. Van Coonet, was the Deputy of the Superintendent General of Indian Affairs.
thank you. So they're all listed as attendees. And then if we look at page 123, that's page 123 of the compendium. And I notice as well that, can you read who is indicated to be joining here after the morning adjournment at the top of the page there?
Yes,
Sorry, which page are you going to?
And
108?
123, Your Honor. 123 of the compendium.
Got it.
Yes, it says also G.W. Burbidge, Esquire, Deputy Minister of Justice of Canada.
So he also joins the meeting. And we had a discussion yesterday about Mr. Courtney ultimately recognizing that he had made a mistake about the capitalization. Do you remember that discussion we had?
Yes, I do, that he had counted one of the amounts twice. Yeah.
And while we're on the same page, maybe you could tell us about the second highlighted block there that we've provided. Does that help to refresh your memory about when that error was noted by Mr. Courtney?
Well, yes, it says Courtney stated that during the recess, he had examined the several items and was of opinion that the $88,000 should have been taken off the account charged to the capitalized annuities, and that it was in fact charged twice in the accounts.
Yes, thank you.
I'm sorry.
So then if I can ask you to turn to page 115 of the compendium. This seems to be starting after some introductory remarks. And I wonder if, when you look at page 115 and 116 and so forth, if you would agree with me that, in fact, there's a number of items to be discussed at this meeting for the settlement of accounts. It's not just Indian matters. Would you agree with that?
Yes, that's correct.
And can you tell me, please, what other sorts of things that you see here are being discussed just in page 115 and 116?
What I see on this page is Upper Canada Land Improvement Fund
Yes.
and interest.
And on page 116?
Oh, I'm sorry. Also, it says bottom Rockwood Asylum,
Yes.
and on 116 slides.
Not sure what slides are,
I
but
think that might have to do with timber slides, but not sure about that either.
okay, and then on page 117,
117 Montreal Turnpike Trust. Courthouses, Quebec, and Indian annuities.
we're going to focus our attention, of course, on the Indian annuities, but you'd agree with me that there's a number of outstanding matters that still need to be sorted out. Isn't that right?
Yes, I would agree with that.
Okay. And then if we look at that Indian annuities, we see that in fact, these are the numbers here that Courtney
Sorry,
had provided.
what page have you arrived
Oh,
at?
excuse me, I'm on page 117, Your Honor.
Got it. Thank you. Go ahead.
Are you there?
Yes, thank you.
So on page 117, under Indian annuities, we see arrears of payments to Indians under our treaties. Those are the Robinson treaties.
Yes, that's correct.
And in the amount of $140,800.
Yes,
And then capitalization of annuities, I think that's $303,880.
yes.
I'm
And-
just going to, I'm having a hard time deciphering my document, so I'm slow on this.
How can I be of assistance?
No, I'm just trying to follow you.
We're at page 117. Of course.
What's displayed on the screen isn't matching with the page, with what we're looking at right now. I think we're, oh, I'm sorry, it is. Yeah, my mistake. It is.
It's the haze.
Okay. So I think you'll agree with me that these are the numbers that Mr. Courtney had put in his new accounts. Is that right?
Yes, it is.
And that these were the same numbers that in the earlier correspondence between Mr. Ross and Mr. Courtney that we looked at yesterday, that Mr. Ross had asked for explanations on. Would you agree with that?
Yes.
Okay.
So are either of you saying these are the double counting entries or the corrections?
So at this point, these include the double entry. It's later that Mr. Courtney, as Professor Messamore has just read out, it's later in the day that he realizes that he had in fact made a mistake. Would you
Okay.
agree with that, Professor?
I'm sorry, I would have to refresh my memory about that point.
Okay, so we're at the beginning of the meeting here at page 117.
Yes.
And then we saw a moment ago that on page 123, after the morning break, or perhaps the lunch break, it says that they came back at 2 p.m. Guess that would be the lunch break. You just read that passage that he had stated that during the recess, Mr. Courtney that is, had examined the several items and was of opinion that the $88,000 should have been taken off the account charged to the capitalized annuities, and it was in fact charged twice in the accounts.
Yes, I would certainly accept that it was charged twice in the accounts. I was just thought it would be helpful if I could confirm this exactly what the overall number was, but I would take it on your calculation that this was, it would make sense in sequence that if it's only afterward raised, that Courtney acknowledged the mistake that.
And I was just really pointing it out that, you know, after the back and forth that the gentleman had had earlier in the calendar year that we looked at yesterday,
Yes,
the letters of February 1884 and then June 1884, Mr. Courtney is now essentially acknowledging that Mr. Ross had been correct.
that's right.
Okay. So I think with that, we can move on. If we turn to page 120, 120. So this to me looks like a transcript. We see the middle of the page, a paragraph that begins Mr. Ross, colon.
Yes,
You see that?
yes, I do.
Okay. And then it's being blown up. That portion of Mr. Ross, it's not highlighted. I had forgotten to do that, but I'd like to look at a portion of it now. It says in the middle of that Mr. Ross section, it begins with "now I contend." Do you see that? It's
Yes, I do.
about 6 lines down, Your Honor.
Yes, thank you.
It says, Mr. Ross, "Now I contend that the Dominion, in assuming a fixed amount and capitalizing the annuities as they did at the time of the arbitration, virtually settles the amount of these annuities and assumed the risk of there being an increase. They assumed the liability subject to the contingency." Now, first of all, I'm sure you agree with me that that's what it says.
Yes, that's what it says.
And would you also agree, I think that the arbitration at this point that he's discussing is the 1871?
Yes,
Right.
yes, the section 142 arbitration. Yeah.
Yeah. And, this is Mr. Ross speaking, but would
Yes.
you agree that it is his view that Ontario was no longer responsible for annuities because of that capitalization and that arbitration? Would you agree that that's his view?
I would agree that that was Ross's view, yes.
Okay. And then if we look at page 132, and this is under the heading Mr. Ross's argument.
Yes.
We also again see Mr. Ross speaking. And he says, "With reference to these Indian annuities, the first point I take it that we are not liable at all from any claims for arrears under the Robinson treaties. That when the annuities were capitalized at $88,000, as they were at the time of the arbitration, with the consent of the Dominion and the provinces, the Dominion assumed them at that sum, and that was a virtual settlement of them. They were assumed at that sum by the Dominion, and the Dominion ran the risk of any increase that might be thereafter claimed by the Indians." You agree that that's what that passage said?
Yes, I do.
And so Mr. Ross is reiterating his view, Ontario's view.
Yes,
And that's that they believed, Ontario, the province believed, that the $88,000 capitalization was meant to be a settlement of sorts for Ontario's liability.
yes, that's his understanding.
And would you agree with me too, that that is essentially consistent with the view of Attorney General and Premier Mowat 10 years earlier that we looked at yesterday?
I can't remember specifically what Mowat said. It might be helpful to review that, but I think it wouldn't surprise me to learn that Mowat made that point 10 years ago.
We can certainly go back to it. That was tab 10 of the compendium.
Okay.
And
Yep.
on the last page of the letter, at page 148 of the compendium, we see a reference by Mr. Mowat, Premier Mowat, that the arbitration under the British North America Act and the arguments raised there had established that the province is not liable to be charged with the Indian annuities. You see that?
I see what you're referring to. So it says, this is Mowat's letter. And he says, if I may read it, the question of the liability of Ontario in respect of the Indian annuities was fully discussed by the respective council for the provinces of Ontario and Quebec before the arbitrators appointed under the BNA Act. And the undersigned is of opinion that the arguments which were advanced by counsel then representing Ontario and which were afterwards printed established conclusively that this province is not liable to be charged with the Indian annuities. So he's saying that that was the argument of counsel at the time. I would accept broadly that Mowat would support this view himself.
And I was just really suggesting that Ontario was of the view that this was dealt with. Whether that's accurate or not, that was certainly Ontario's view by Mowat in 1874 and by Ross in 1884. Would you agree with that?
Yes, I would.
Could I just ask you, you referenced tab 10,
Yes, Your Honor, it's the Mowat letter.
page 140?
Page 148
8.
was what I first took.
Sorry,
Professor
I was
Messamore
missing
too?
page 140, so I've got it. Thank you.
I should note that after court yesterday, my friend Mr. Schachter helpfully pointed out that in a version of the letter that he has at the back of tab 10, that page 148,
Yes.
he believes that it is the Minister of the Interior. That was something that Professor Messamore thought it was likely, and I think Mr. Schachter will agree with me that that's what you demonstrated to me.
Well, that's my reading of the document. I thought my version might have been just a little. But
I don't think either, but to the extent that there was, we were trying to figure it out, I wanted to be clear that.
Thank you.
Okay, yes. Can we turn back to tab 9, please? I wanted to look at what Quebec's view was. If we at page 120 of the compendium, yes.
Yes.
Now, I note that on this page, it says Mr. Robinson.
And that would be Robertson. That's a typo. Yeah. Yeah.
I was going to ask you about that. Everywhere else, he's referred to as Robertson. Mr. Robertson was the treasurer for Quebec, you told us, right?
That's correct.
And then if we look at page 120 of the compendium at the bottom, who we now know to be Mr. Robertson for Quebec, he says, "It seems perfectly clear to me that this sum of $88,000 was fixed upon by the Dominion government. Query, can that government afterwards, of their own motion, and without the consent of the two provinces, increase the amount to be paid? It seems to me they cannot." See that?
I do see that. Yeah.
And then if we look at page 135, we see Mr. Robertson speaking again at the top of the page. The top of the page.
I'm sorry. Yes.
So here we see again, so far as Quebec is concerned, it appears to me that capitalizing these annuities at $88,000, it's hard to read there, but I think it says was
Yes.
done in the statement of debt by the Dominion presented to the arbitrators ought to be considered as a finality, especially as the Dominion was notified by both Ontario and Quebec that no increase should be made to the debt without their consent. Do you see that?
I do. Yeah.
Would you agree with me that Quebec's position, Quebec's position, was essentially aligned with Ontario's in that the $88,000 was supposed to be the end of annuity obligations for the two provinces.
That was Quebec's argument, yes.
That was his argument.
Yep.
And I'm sure you'll agree with me that Canada had a different view.
Yes,
Okay. But then because of this discussion, you told us as well, I believe, that Mr. Courtney agreed to take those annuity amounts and put them into a suspense account.
I think insofar as it was a point in contention, yes,
That's right,
Yeah.
because there was a disagreement.
yes.
Okay. Now, if we move ahead in time another 10 years,
Mhm.
we then get to the Dominion provincial arbitrations, as you've called them.
Yes,
And in 1894, we have a hearing before those new arbitrators, and the award number 3, as I call it,
Mhm.
comes out of that. That's the one dealing with the Robinson annuity specifically.
yes,
Okay. So would you agree with me that this same theme of the $88,000 being a settlement was raised before the arbitrators for that hearing?
yes,
And you'd agree with me that Quebec and Ontario were reiterating those same points,
yes, among others.
among
yes.
others, of
Yeah,
course.
yeah.
But in fact, the arbitrators, as you pointed out in your testimony, they said that it wasn't a settlement and that paragraph 4 of that decision, we can pull it up,
Mhm.
said pre-Confederation, it's a UPC responsibility still.
Yes,
Okay. So if we look at your slide deck 213, might be best to look at that now. Donna, are you there?
Thank you.
So Professor Messamore, this is a slide where you set out the Dominion Provincial Arbitrators ruling in paragraph 4 of the third award. Is that correct?
yes, that's right.
And I'm just going to read it. It says, any liability to pay the increased amount in any year before the union was a debt or liability which devolved upon Canada under the 111th section of the British North America Act 1867, and that this is one of the matters to be taken into account in ascertaining the debt, the excess of debt for which Ontario and Quebec are conjointly liable to Canada under the 112th section of the Act. And that Ontario and Quebec have not, in respect of any such liability, been discharged by reason of the capitalization of the fixed annuities or because of anything in the Act of 1873, 36 Victoria, Chapter 30. So that's what the arbitrators decided following the hearing about that, right?
Yes, that's correct.
And do you agree with me that, of course, the capitalization of the fixed annuities is the $88,000?
I'm sorry,
The capitalization of the fixed annuities that is
Oh.
being discussed at that point, the only annuities that have been capitalized, indeed, the fixed annuities, that's the $88,000.
well, what was capitalized at the time of the Section 142 arbitration, right? And so I understand here a context is a liability to pay any increased amount above that. Is that, am I
Of course,
understanding you?
But the
correctly?
reference to the capitalization of the fixed annuities, that is a reference to the $88,000.
Oh, in the last part of this,
Yeah.
yes, yes,
And that the Act of 1873, that's the May Act that increased the debt allowance.
that's correct.
So My understanding of this portion is
Mhm.
that Ontario and Quebec lost their argument before the arbitrators that the $88,000 got them off the hook.
That's my understanding as well.
Okay, thank you.
Sorry, lost their argument that the $88,000 got them off the hook.
Mhm.
Got it.
Okay, so at that point in time, the arbitrators have said, you may have argued in front of us that $88,000 ended your liability, or that the Act of 1873 ended your liability, but no, it did not. Right? We agree with that?
Yes, I would.
So, and when you use the term got them off the hook,
That's a bit colloquial. Let me rephrase that.
but your reference is for future increases to the annuities.
Yes, because they had been arguing, as Professor Messamore and I have discussed, Premier Mowat, and then Treasurer Ross, and then Treasurer Robertson had all been arguing that the provinces of Ontario and Quebec did not have any further liability for Robinson annuities because of this
As in
capitalization.
future,
Yes,
got it.
because the
I-
discussion of Mowat and then the meeting in 1884, Professor Messamore has agreed with me, I believe, was in the context of the increases that were now being paid and the capitalization for them, right?
Well, I think it was concerned both with arrears and with capitalization for future.
But the
So-
arrears were for augmented annuities. There was no
Yes.
question of arrears. At no time do you understand that even the base annuities had never been paid and had gone into arrears. Arrears were only in the context of an increase, isn't that right?
Yes, arrears of an increase, yes. So there was something Your Honor said a moment ago that I felt I wanted to clarify. and
Oh,
I
you
just-
thought I went too far?
Uh, No, I wish I could remember the exact phrase. I just.
Well,
was
my
concerned that-
my question to Ms. Barkley was just to really to ask her to finish off the question. The question she put to you was Ontario and Quebec lost their argument that the 88,000 got them off the hook.
Yes.
And so my question was, got them off the hook for future increases to annuities?
That was the point, Your Honor. What I think, my understanding of this was that Ontario and Quebec had believed that section 142 arbitration was forever settling the question as to future increases or arrears that stretched back into the pre-Confederation era. And so my point is that they were, according to this ruling, not off the hook for any of those things, that it didn't only concern potential, what amount should be capitalized for future potential increases, but also arrears that exist or that were deemed later to exist up to the time of the section 142 arbitration. So I think if I can infer what the Dominion provincial arbitrators were saying, is that this was simply a capitalization at the time of the section 142 arbitration of the obligation as it was then understood, but it wasn't to be considered a blanket coverage for anything else that might later become due for this or for any other matter for that. Section 142 arbitration only dealt with the known debts and liabilities.
And if I may,
Go ahead.
and not to put too fine a point on it, but there's a nuance here that I'd like to point out. Because paragraph 4 that we looked at slide 213, you agree with me that it's not referencing back to the 142, the section 142 arbitration. It's referring, I think we've discussed, to an argument that the capitalization of the fixed annuities or the Act of 1873 had not discharged future liability. You agree with that?
I'm not sure I'd make such a distinction because.
Can you tell me why you disagree with that?
Well, I guess what I would say is that the section, they determined what amount would need to be capitalized to cover the annuity obligation in future. At the time of the section 142 arbitration, as I understand it, it wasn't entirely clear at the outset that this would indeed be how the Robinson Treaty annuities would be dealt with. You'll recall that Quebec made the argument that they ought to, for future, be considered a Section 109 trust.
Which they lost.
Which they lost, exactly. So I would suggest that the capitalization, although, you know, we've established that that was worked out by the Auditor General in 1869, what exactly the total debt would be calculated to be for the purposes of the Section 142 arbitration, and determining and apportioning it between Quebec and Ontario wasn't entirely determined, I guess we could say.
Okay, let's go back a bit. The capitalization of the fixed annuities, do you agree with me, was fairly easy math?
Yes, it was.
It didn't matter about numbers of annuitants.
Yeah, for the fixed amount.
For the fixed, we're
Yes,
only
correct.
talking about the
Yes,
fixed.
of course. Yeah.
So the $88,000 of the fixed annuities, that was capitalized. And then we've seen that Ontario and Quebec were arguing, perhaps incorrectly, as the arbitrator said,
Mhm.
but their argument was this meant that we did not have any further responsibilities for these annuities going forward.
That was their argument, yes.
Not suggesting that that lived,
yeah,
that
I
was
understand. Yep.
successful.
Yep.
In fact, I'm pointing out that the arbitrator said, you're wrong, but that was their argument.
Yes.
Thank you. So I want to go back to the arbitration of 1870. I want to actually now shift, Your Honor, to talk about arbitrations generally.
Thank you.
That's helpful. And I want to start with the very first one, the 1871.
Okay.
Now, when we talk about that in terms of 1870, of course, but in fact, there were a number of meetings for that arbitration, and they started in August 1869. Do you agree with that?
Yes, I do.
And they ultimately culminated, I believe, in September 1870. Do you agree with that?
Just determining, I don't remember the month, but if you say it was September, I would accept that.
But we'll come to some documents
Okay.
that I think make that clear, but. And would you agree with me as well that this was not just an arbitration about Indian annuities?
That's correct, yes.
There was a number of matters before the Section 142 arbitrators that they needed to use the phrase of Section 142, divide and apportion the debts and assets and property of the former United Province.
Yes.
And then at slide 146 of your demonstrative, you could turn to that. You see that?
Yes, I do. I'm sorry. Yeah.
Are you there, Your Honor?
Go ahead.
So here you're talking about the 142 arbitration. And you say a judgment was rendered on 28 May 1870 of McPherson and Gray alone.
Yes.
See that? Now remind us who McPherson and Gray were, please.
The representatives of Ontario and the Dominion respectively.
Right. And then after this May 28, 1870, you call it a judgment, it's true as well that Quebec's arbitrator took issue to it. May I say that?
Yes, yes, that's right. Yeah.
And ultimately he resigned from the arbitration panel because of it. Isn't that right?
Yes, he did resign. I mean, when you said ultimately, his resignation was prior to this.
Not
As
to
I
May
understand.
28. Do you disagree with that?
Gosh, you know what? I'm sorry, I don't remember the exact date of his resignation, but
Okay, well, we're gonna go through it in a minute. We'll
yeah,
get there.
okay.
So this May 28 decision, would you agree with me that the two arbitrators who did sign it were then McPherson and Gray?
Yes, that's correct.
Would you agree with me that they saw that decision or the judgment, as you phrase it, as an opinion or a guide for proceeding with the division of assets and debts of the UPC?
Yes,
And then it was after that they, using that guide, tried to actually apportion all of those things that needed to be divided.
yes.
Now, the decision, the opinion of May 28, 1870, that didn't end up being the final award of the Section 142 arbitrators, was it?
Well, in terms of final award, the final award determined a proportion
That's right.
based on the process that took place in the interim of determining
That's right.
the various items that had to be allocated.
And I wanted to point that out because you have actually a portion of that award at slide 147,
Yes,
but I don't think we had an opportunity to look at it.
okay.
This is the ultimate award that then gets referred to later by the Supreme Court, and it's the September 3, 1870, Section 142 award. Isn't that right?
Yes,
So it's this September.
September 3,
Thank you.
1870. And then, can we turn to tab 11, please? Do you have it?
yes, I do.
Okay. So this is an interesting document in the sessional papers. It's a compilation of things I might suggest. If we can flip through it to orient ourselves, it starts off with correspondence, and in fact, there's a sort of index, if you will, at the beginning here, the first page at 149. It starts with correspondence between Ontario and Quebec, and in particular, the Honorable Attorney General of Ontario to the Honorable Gideon Ouimet of Quebec.
Yes, I see that. Yeah.
And was Mr. Ouimet, was he the Premier of Quebec?
I'm sorry, at this point, I don't know.
For what it's worth, I think he was. I think
Okay.
it was the Premier speaking to the Premier, but nothing turns on it.
Okay.
And then it includes, if we turn to different page numbering on this, there's the page numbers at the bottom, and then the page numbers on the top. If we turn to page 176 of the compendium, the bigger number on the top right. These seem to be essentially the appointments of those arbitrators for each of the provinces and the Dominion. Ontario's is at page 178. And then at page 179, we're into the meetings of the arbitrators. Do you see that at the bottom of the page?
I'm sorry, page 179.
I'm at page 79, page 179, yes.
And I'm sorry, on this page, you want to direct me toward what?
Well, we start then after the appointments of the arbitrators being read out at what I take was the first meeting of the arbitrators. We then get into sort of itemization, as you, if you will, over the next several pages, many pages. And this one says the second meeting of the arbitrators.
Yes.
And then, you know, we turn the page, we get the third, the fourth, the fifth. Do you agree with me on that?
Yes, I do. Yeah.
So I take it in the sessional papers then that this is a document that reflects those meetings. Would you agree with me?
Yes, I would.
And one of the questions that I had that I was a bit confused about in your testimony on Friday and Monday was that you said that there was a transcript of the hearings before the Section 142 arbitrators. Is this what you meant?
No, it's not. No.
Okay,
No.
I'm not familiar with that. Are you able to point me to a
Um,
transcript? I don't,
Okay, gosh. Record of proceedings. So I see that in my report, I cite that at footnote 206.
206?
Yeah, my footnote is number 206, record of proceedings in the matter of arbitration and award under the 142nd section.
Okay, I see that. Thank you for that. I will take a look at that.
Okay,
What I wanted, I was looking for, I was trying to make sure that our terms were being consistent.
Hmm.
But I'm going to refer to these meeting minutes. And I wanted to turn up, well, maybe what I want to do first is to talk about Day's resignation. We have a number of meetings of the arbitrators here, as we've seen. And they begin the second meeting of the arbitrators on page 179. It demonstrates that at least the second meeting was the second day of September, 1869.
yes.
Sorry, what was the page?
I'm at page 179.
Thank you.
I'm just pointing out that there's a number of meetings over a year. And then if we turn to page 185, we have the 19th meeting of arbitrators. Do you see that?
Yes, I do.
And that was the 28th day of May, 1870.
Ah, yes, yes. And Day was present at that point.
That's right. It says they met on a Saturday.
Yeah.
And if you take a look at this 19th meeting of arbitrators, it looks to me that what's happened here is that beginning with the Honorable Charles Dewey Day, he sets out his propositions for how the arbitrators should proceed to apportion the debts and liabilities. Can you look at that? There's 3 numbered paragraphs. Is that what you take him to be doing?
Well, it'll take me a moment to read
that's
this
fine.
and see. Oh, yes, yes.
Right.
So I see that there's some elements, you know, the document I use that's described as proceedings. There's some, you know, that often you have the same material appearing in different documents. And I recall reading this in the document that I referred to.
Okay.
So it
and-
wasn't in sessional papers, but that's,
And really the point that
Yeah.
I wanted to take you to
Yes.
is there's he lists out, and they're numbered paragraph 1, paragraph 2, paragraph 3. And then there's 2 paragraphs that say upon the question, upon the question. And in those, we see, would you agree with me, essentially, it looks like it was a vote of the arbitrators. And that the propositions for division that Mr. Day, I think Judge Day, was proposing, Ontario and Quebec disagreed with them. Is that correct?
yes, it is.
Okay.
I'm sorry that two, the-
Ontario and,
And the Dominion.
Excuse
disagreed
me.
with it.
Yes,
I'm
of
sorry.
course. Thank
Yeah.
you for that
Yeah.
catch. The propositions by Quebec were disagreed with by the arbitrators of Ontario and the Dominion.
That's correct.
Okay,
the propositions made by Day on behalf of Quebec.
that's correct.
Thank you.
The arbitrator, I'm not sure it's on behalf of Quebec as an arbitrator, but the representative
Representing.
from Quebec,
Yes.
Thank you.
the arbitral representative chosen by Quebec. Ontario and the Dominion voted against them. And then we have McPherson beginning with his propositions, and you've reminded us that he was who? He was the Dominion?
No,
He was
McPherson was
Ontario.
Ontario. Yeah.
And then you agree with me that he sets out his,
Now are we on page 186 now?
well, we're at the
Or no, I'm
bottom
sorry,
of
we're starting at 185.
185.
Yes, yeah.
As it says, so the whole three propositions of the Honorable Charles Dewey Day were rejected.
Yes.
And then we have Mr. McPherson submitting the following grounds. And he lists his. And he finishes,
So we're now on page
where he
186.
finishes over the page 186. He has four propositions.
Yes.
And then about the middle of the page, it says, upon the question on this proposition being put forward, it was negatived. And
I'm sorry, we're here.
um,
Oh, yes, I'm sorry. Yeah. Little.
Numbered paragraph 4.
just below numbered paragraph 4. I mean,
A little bit before the middle, yes. upon
essentially the
question.
point is, Ontario then put forth its ideas, and now we have the Dominion and Quebec disagreeing with Ontario.
Yes.
Then we move to Canada's representative, right?
Yes.
Okay. And he sets out his,
Yes.
and then toward the bottom of the page, we see that upon the proposition, on the question on this proposition, for it was Gray and McPherson, and against it was Day.
That's correct.
And then we have this little explanation here. It begins, I'm at the bottom of the page,
Page 186.
186. It says that the Honorable McPherson said that while adhering to his preference, that's Ontario's preference, for population as the basis for division and adjustment of the debts, credits, liabilities, properties, and assets of Upper Canada and Lower Canada, he nevertheless assents to Colonel Gray's, that's Canada's, right,
Yes.
proposition with the view of arriving at some basis and believing that under it a just award may be made. You see
Right.
that?
Yes, I do.
So I take it then that he was agreeing to move forward with Canada's idea, although it wasn't his first choice.
I think
Sorry,
that's correct.
Ontario.
Ontario was agreeing. to
Ontario
move
was
forward.
agreeing to accept Canada's idea of moving forward in the spirit of compromise. It wasn't his first choice. Do you agree with that, Professor?
Yes, I do.
And then what happens, I take it, is that Mr. Day, excuse me, Judge Day writes a dissent, and we see that at the bottom of page 187.
Yes.
You see that, 187 through 188?
Yes, I do.
And then what follows, and perhaps you remember from your own review of your version of this, is that there's a discussion about releasing this decision because it's a majority decision. Do you agree?
A majority, yeah, a decision by 2 of the 3 arbitrators. Is that what you mean?
Yes, that's what I mean.
Yes.
And that
Um,
Quebec objects to that.
I'm sorry, what page are we on here to see this?
Starting at page 190.
Sorry, was the first proposition you made, Ms. Barclay, that then Day writes a dissent, and that's 187?
That begins at the bottom of 187, Your Honor, and it continues through most of page 188.
Right, and then your next question was,
Don't remember it exactly, so I'll rephrase it.
well, I think, I just want to follow. Quebec writes a dissent, but then you say
Oh, I
that,
remember, yes.
that
Well, then there's
Quebec
a dis-
objects to sending out a majority decision?
And then there's some meetings that take place after May 28th and into July, where there's essentially, because it's a majority decision, or what Ontario and Canada's representatives feel is a majority decision, the representatives at these meetings for Ontario and Quebec want to move forward with the division based on that majority decision. Do you agree with that, Professor Messamore?
Yes, I do.
And do you agree with me that,
So I just want to check. You just said that Ontario and Quebec want to
Oh,
move forward with the
I'm sorry.
majority decision.
I'm sorry.
I don't know why I
You-
keep doing that.
And I
You-
agreed with it. I'm sorry.
Okay,
Sorry, that
let's
was-
reel
was-
it back.
yeah.
Thank you, Your Honor. Ontario and
And-
Canada
Yes,
were of the view that they had a majority decision,
yes,
and they wanted to move forward to be able to divide the assets and the properties and whatnot. Isn't that right?
yes, it is.
And they wanted to do that on the basis of that majority.
Yes,
And Judge Day had written a dissent.
yes,
And then we see in this record that there's an attempt, if I may say that, by Quebec to hold back the decision because Quebec disagreed with it. Do you agree with that?
yes, I do.
Okay. And then it seems to me that it comes to a bit of a head. And we see, beginning at the bottom of page 190, under the heading 24th Meeting of Arbitrators, which was on the 9th of July, 1870. You see that?
Yes, I do.
You then have another heading that says opinion of the arbitrator appointed by the Dominion government. You see that?
Yes, so that would be great.
This would be John Hamilton Gray,
Yes,
the one from New Brunswick.
yes,
And he describes in the next few pages what's happened and the disagreement. And at the bottom of page 191, the last line there I'm going to start with, page 191. This is Mr. Gray, Hamilton Gray speaking. He says, are you there? Bottom
Yes.
of page 191?
yes, I am.
If this was a private matter, there would be no difficulty about it. Parties having agreed to a reference and having requested a decision, whether interlocutory or final, must take it unless by consent it is abandoned. Do you see that?
Yes, I do.
Then skipping a paragraph, he talks about how important it is, but skipping a paragraph, he says, I have exhausted every effort to bring about an agreement on this point between my two law colleagues and have delayed giving any opinion until compelled by the necessity of the arbitration being either abandoned or proceeded with. A week has elapsed on availing efforts to do so, and I am most reluctantly compelled to decide. And he goes on. This is the highlighted portion of this page 192.
Mhm.
I have to observe that the decision of the 28th May last is not final. It is not like an award of the arbitrators on the division and adjustment. it is only an opinion of the majority of them as to the best mode to proceed in the division. If in working it out, it is found to operate unfairly, it is open to be reviewed and rescinded, and such other mode adopted as may be shown to lead to a fairer result. It is admitted by the arbitrator for Quebec that in proceeding under this mode, the inquiry will necessarily expand itself into the consideration of much that would be embraced under the view of partnership advocated by himself, but it does not admit the existence of a partnership or limit the investigation to the rules which would govern a partnership. Do you see that?
Yes, I do.
Okay, so do you agree with me that the arbitrators at least, well, a few things. Mr. Gray here is saying, we're going to move forward.
Yes,
Okay. And that
On behalf of Canada.
well, Mr. Gray
or
on
as
behalf
an
of
arbitrator.
Canada is saying, we have a majority decision. Our task under the Constitution, 142, is to divide these assets. We have a majority decision. We're going to move forward with that.
and divide the excess of debt.
But he's also saying that, Quebec, to the extent that you have a concern,
Mhm.
this May decision that you've dissented from, it's a guide. Would you agree with that?
Yes, I
That's what
would.
he's saying?
Yes,
And if it doesn't work out, we'll deal with it.
yes.
And ultimately, we know that Day doesn't like this,
Yes,
or perhaps more accurately or fulsomely, the province of Quebec doesn't like this. So his resignation is tendered and he withdraws from the arbitration. Isn't that right?
yes. And as again, I can't remember the exact date of his resignation, but yes.
Yes. You agree with me, though, that it happens before the final judgment of the arbitrators on September 3rd, 1870, because Quebec
Yes.
didn't sign on to that.
Yes, exactly. Yeah,
So I don't think it matters the exact date. We can
Yes.
find it if you wish.
yeah, no,
but
it's not important. And we know it was in that interval.
Yeah, he didn't like it. Okay. And would you agree with me then that after the two arbitrators or arbitrator Gray on behalf of Canada says, we're going to move forward, that in fact, in subsequent meetings, they meet to now try to use those May guidelines to divide those assets
And liabilities.
and liabilities, of
Yes,
course,
yes.
and the properties and whatnot.
Yeah.
Okay.
Yeah.
And would you agree with me that sometimes they found that those May guidelines, they weren't particularly applicable because the asset or the debts didn't leave an asset?
Yeah, that it's, I described it, I think, as an imperfect process that, the principle was broadly local benefit, but it wasn't a matter of exactly matching liabilities to assets.
That's right.
Yeah,
And one of the examples that is given is the land system in Quebec, the seigneurial landlord system. Do you remember that?
not specifically, no,
Okay.
but
I guess the only point to take away is that the guidelines worked where there was a physical asset like a bridge.
mhm,
A bridge was created by this debt. Here's an asset
Mhm.
and here's a debt. Would you agree with that?
I think so. But as you say, it was a rough guide.
Yeah, it was a rough guide.
Yeah.
Okay. And then ultimately, what we do get is the award of September 3rd, 1870, right?
Yes,
And that's the one that you said apportioned the conjoint liability to be the 52.77% for Ontario and the 47.23% for Quebec. Do you remember that?
yes, I do.
Okay. How are we doing for time? Now, in your report and in your testimony, you wrote that in December 1869, so this was during the meetings of the arbitrators under section 142,
Yes,
that Quebec's council submitted a memorandum for the arbitration hearing that set out that province's views that section 109 applied. Do you recall that?
I do.
So that was submitted, of course, in December 1869. It was submitted before Judge Day resigned.
Yes,
And Quebec's council, you told us, was Mr. Louis Napoleon Casson.
correct.
Now, I'm not asking, of course, for your legal opinion, but from your review of the historical record and your understanding of it, you agree, I think, that what Mr. Casson, on behalf of Quebec, was arguing was that Quebec should not be responsible for annuity payments relating to treaties that now were with respect to Upper Canada.
Yes,
That's fair? Okay. And then, as we've discussed, the arbitrators, they didn't agree with that argument. Is that fair to say?
well, I think it's important to note that there was an argument then made by Cameron for Ontario that sort of turned on 2 points. One being that the so-called old annuities, the ones that were reflected in the 1846 civil list, had produced the territory those annuities concerned had produced, I think he said 10 times the amount that had been expended, and Lower Canada, as part of the province of Canada, had enjoyed those benefits. And so it was fair to divide responsibility for those annuities, even though the territory covered by them was in Ontario. And that with respect to the Robinson treaties, we could use the convenient offsetting lower Canadian annuity amounts in the amount of £1,000, which would be roughly equivalent to the ongoing Robinson treaty annuities. So I wouldn't say so much it was that the arbitrators rejected the 109, section 109 argument, as that the point was deemed to be moot because we could use this convenient offsetting obligation in this admittedly imperfect process.
We'll come back to that. You've saved me a
Okay.
few questions, for which I thank you. But my point was
Okay.
going to be that Quebec, Mr. Casson for Quebec had made the argument that section 109 applied.
That is correct.
And the arbitrators, they didn't use section 109 in their decision, did they?
They did not.
So I actually want to look at their decision if we could. And by this, I mean the final award of the section 142 arbitrators.
Okay.
And it's found at tab 11 of our compendium, starting at the bottom of page 210 with the recitals, which I don't think for our purposes are necessary to go through. So maybe we could look at page 211. You have it? I do. Your Honor, we're at page 211,
Thank you.
tab 11. So in paragraph 1, you agree with me that this apportionment that we talk about, this 52.77 and 47.23 for Ontario and Quebec respectively, it comes from the numbers at paragraph 1. Would you agree with me on that?
Yes.
Somebody's obviously figured out the math at some point along the line, because I've not actually seen anything that puts that actual ratio into clear letters. Have you?
It puts it into clear
The
letters
numbers.
in terms of a percentage.
Yeah.
Um,
Are you aware of anything?
I feel that I am, but I can't tell you at this moment where. I
Okay.
got
But we
that.
agree that it comes
It-
from this paragraph.
Yeah, I think that I mentioned a couple of reports that have been produced in the 1930s,
Much after the
Um,
fact,
much after the fact.
not a
and I
primary
think-
document such as this.
I don't believe so, but I can't be confident in that point. But I think that certainly somebody worked it out at
Yeah.
some point.
Some accountant, perhaps Langton, worked it out. Okay. And then if we turn the page over to page 214, there's a Roman numeral 13, X111, towards the bottom of the page. Do you see that?
Yes.
And we've talked about this provision in the last few days with my friend, Miss Evans. This is that section that, that talks about how the annuities are to be dealt with. Isn't that right?
Well, not exactly. It talks about, it says that the lands respectively surrendered in consideration of the annuities shall be the absolute property of
It
the
also
province
says-
in which they're situate, free from any further claim upon or charge to. the
Well, it
said
also says, and
province.
what I was referring to, that it says said annuities are included in the debt of the late province of Canada. See that in the middle of clause 13?
I'm sorry. Yes,
Okay.
yes, yeah.
So it deals with the annuities and it orders, it awards that they are to be included in the debt of the late province of Canada.
Yes,
Okay, thank you.
or it acknowledges that they are included, I guess would be a way to put it.
I think that they're determining that they are to be. This is an award of the arbitration.
Well, it says, I think I would accept that they agree that, or that they are including them, but I think this clause, as I read it, and again, I'm not a lawyer, but it's referring to the lands which said annuities are included in the debt shall be the absolute property of the province. And so I think it's kind of about something else, if I understand it correctly, not so much the clause that includes the annuities in the debt, but refers to the fact that the annuities are included in the debt. But as you say, I mean, these are the arbitrators, and so their acknowledgement of that is tantamount to declaring that principle, I suppose.
Well, the issue
Let-
of
let me just
whether,
have a moment to read it.
yeah, of course. And my next question was only going to be as a follow-up to what you just said, Professor Messamore. The question of whether the annuities should be included in the debt was a contentious issue. We've seen that Quebec said, at least with respect to the Upper Canada annuities, that they should not be part of the debt of the province of Canada.
Yes,
So here we see the arbitrator saying annuities are to be included in the debt of the late province of Canada.
yes.
Okay, thank you. If we can turn back to page 211. I think you'll agree with me that while we've only been talking about what are paragraphs 1 and 13 to date, there's a lot of matters that the arbitrators are dealing with.
Yes,
They're dividing up the debts and assets and property, isn't that, and the liabilities, isn't that right?
yes,
And they start in paragraphs 2 and onwards until we get to that where we were just a moment ago, clause 13. They're going through the different debts and liabilities and assets and property, and they're dividing them between Quebec and Ontario, isn't that right?
yes.
Okay.
Yeah, I think section 2 actually deals with assets and section 3 deals with assets. It might be confusing when we see the word debt, but of course, in that instance, the debt is an asset because it's owed to them. Yeah.
Okay. So when it came to these annuities in Upper and Lower Canada, it was certainly within their jurisdiction to say that the Lower Canada ones would go to Quebec and the Upper Canada ones would go to Ontario. Would you agree with that?
When you say the ones, you mean the obligation for the annuity?
Yes, just like they're saying these are Ontario's and these are Quebec's and the rest of the judgment. They could have said that about those annuities. Isn't that right?
Yes, I believe they could have done that.
Okay.
I think that at the same time,
They decided not to.
yeah.
I just
yeah.
wouldn't mind hearing what the witness was about to
Of
say.
course.
I guess what I'm just trying to decide if they had the power to decide that it was a section 109 trust. They certainly had the power to decide on debt under section 142. And this, I think, is again more of a legal question than a historical one.
Well, they had the ability under section 142 to divide and apportion the debts, liabilities, assets, and property of the former United Province of Canada.
They did, yes.
May I continue, Your Honor?
Yes, please go ahead.
Let's have another page, then perhaps we'll take the break. Now, of course, just like the guidelines in May 1870, you agree with me that Quebec disputed the validity of the final award of September 3rd, 1870.
Yes.
And you talked a bit about how that went to the Judicial Committee of the Privy Council.
I'm sorry, I just have to refresh my memory here. Do you have a slide for my presentation or
I can
okay,
see-
yeah, I do. I can find it myself.
Okay.
It's, it begins on 163. So of course, no Supreme Court until 1875. So it went straight to the JCPC.
63, thank you. Right, and I would, if I suggested to you that Canada didn't have a Supreme Court at this time, would that be in your knowledge, your historical knowledge?
Yeah, there was a plan for one.
Yeah.
But it had not been put in.
In
place yet.
1870, it didn't exist. It existed as
Yeah.
of 1875, isn't that right?
Correct, yeah.
So at this point, you're going to Britain. You're going to
Yes,
the UK.
that's right. Yeah.
All right. And just before we break, I wanted to just finish this section by looking at Quebec's appeal, as you put it. And if we turn to page 220, I'm still at tab 11.
Oh, yes.
Are you there?
Yes, I am.
We see at the top left corner highlighted, it says it's the copy of the special case. And that's the special case that's put, it's what lawyers might call a reference today, that's put to the JCPC, or it's an
Yes.
appeal of sorts. And then there's questions at the bottom. It says the questions for the Judicial Committee of the Privy Council are as follows. You see that there?
Yes, I do.
And these were put forward because Quebec was disputing the validity of the award, isn't that right?
That's correct.
Okay. And if we look at these, I'm going to paraphrase rather than read them out, but please tell me if I misstate them. Essentially, Quebec's appeal was focused on whether there could be just a majority decision or whether all three arbitrators, one of the points was that whether there could be an arbitration decision that was valid when only two arbitrators had signed on to it and not all three. Is that fair?
Yes, that's right.
And then the other main point of contention for Quebec was whether or not the arbitrator from the Dominion, John Hamilton Gray from New Brunswick, had disqualified himself by virtue of the fact that he had, seems a bit silly, that he had rented a place in Ottawa. Do you remember
Yes.
that?
Yes, I do. That he moved to Ontario and so was no longer a,
Right.
a resident of neither province. Yeah.
And that was, of course, a reference to section 142, which said that the Dominion representative could not be resident in either Ontario or Quebec. Do you remember that?
Yes, I do.
So seems a bit silly. I'm not sure how the arbitrator from New Brunswick in 1870 without modern technologies of Zoom could come
Yeah.
to these meetings without being there, but
Yeah,
that was
that's
one of
it.
the things that Quebec raised as its appeal, right?
Yes, that's correct.
Okay. And then you agree that, of course, that the JCPC heard argument about all of this
Yes, yes,
and that ultimately they confirmed the validity of the award.
yes.
Thank you. Okay, perhaps we could break there if that's convenient.
Great.
Or recess for 15 minutes. Or I was thinking maybe see this.
Welcome back. Your Honor, Professor Messamore, before our break, we had finished the discussion about the 1870 arbitration
Yes,
and the final award of the arbitrators of September 3, 1870. And still in the subheading, Your Honor, of arbitrations, I'd like to move ahead now about 20 years and to talk about what you've referred to as the Dominion provincial arbitrations.
okay.
Okay. And those arbitrations were convened through or created by legislation, isn't that right?
Yes,
Okay. And in fact, Ontario, Quebec, and Canada, they all passed nearly identical legislation. You agree with me?
yes, I do.
And before they did that, you mentioned that there were meetings to discuss how they might move forward with this. Isn't that right?
Yes,
And in the agreements that led to the legislation, they agreed that for these new arbitrations, 2 arbitrators could make a decision.
yes, they decided to head that one off at the, at the
Isn't that
beginning,
right?
yeah.
Okay. And that, in fact, the appeals could now be taken to the Supreme Court if necessary.
If they decided on a point of law, I think.
Yes.
So I think otherwise it was explained that they need not proceed on the basis of a strict
Yes.
point of law, but if they did, then that part was subject to appeal.
But to the extent that that rather bald section 142 didn't say anything about what happened if there was a disagreement. Now the legislation being passed said, here's how you can appeal it and on what.
Yes, yes, I think that's fair to
Everything?
say.
And in fact, they got rid of the residency requirement that section 142 said. Isn't that right?
I don't remember that, but I would accept that that could be true.
Okay. And I think they likely did that because of the conflict that arose.
Yes, I should imagine.
Okay. And do you agree that this, why don't we actually look at the statutes? If we go to our second volume of the compendium, that's Z2 now, exhibit Z2. And if we turn to tab 14, and at page 279, behind the title page, we see what seems to me to be an act of Quebec or respecting Quebec. Is that right,
Yes,
Professor?
That's right.
And then over the next page, we see the Ontario one.
Yes.
And then the next page, we see the Canada one. Isn't that right? Well, it starts at the bottom.
Oh,
of
yes, right.
280 in
Yes, of
fairness.
course.
It starts 280
Yes.
Canada.
Yes.
Okay. And then I think you've said in your slides and you've agreed with me now that these are reciprocal, what lawyers would call reciprocal or identical legislation.
Okay,
And then in each of this legislation, there's a provision at paragraph 8, section 8. I'm looking at the one for Ontario at page 280. It's highlighted. You see that?
yes, I do.
So it says the appointment of the said arbitrators by order in council and their award in writing shall bind this province, save in case of appeal on questions of law as herein before mentioned. Do you see that?
Yes,
And then if we turn to page 281, we see the similar language similar language about Canada.
yes.
Now we see that the appointment and their award in writing shall be binding on Canada, save in case of appeal.
Yes,
And just to close the loop, on page 279, dealing with the Quebec legislation, it says the exact same thing at section 8, right?
yes,
And then also by agreement, the three governments agreed about what I would call terms of reference, matters that these arbitrators were to deal with. Do you agree with me?
yes, I think so.
Okay, if we turn to page 281, we see under the heading in caps, first agreement of submissions. There's a bolded paragraph there. It says where certain questions have arisen in relation to the settlement of the accounts between the government of the Dominion of Canada, the governments of the provinces of Ontario and Quebec, both jointly and severally, and also as between the two provinces. It goes on to say the acts that we've just looked at. And it talks about referring these questions to the arbitrators.
Yes,
And then on the next page, 282,
Sorry, you say in this paragraph that the terms of reference are defined?
I'm saying that this is a recital to them, which I'm turning the
Oh.
page now to page 82.
Thank you.
And we see, after some further recitals, it starts listing the different things that the arbitrators are to look at and deal with. Would you agree with me on that?
yes,
Okay. And then the ones that might be of relevance to us, we see paragraph 1. All questions relating to or incident to the accounts between the Dominion and the provinces of Ontario and Quebec, and to accounts between the two provinces of Ontario and Quebec. And then 2 says the accounts are understood to include the following particulars.
yes,
And then we have D, the claims made by the Dominion government on behalf of Indians and payments made by the government to Indians to form part of the reference.
yes,
It talks about apportionment of liability. And then if we look at paragraph 4, we see here in this terms of reference and agreement, all the accounts referred to in this agreement shall be brought down and extended to the 31st day of December, 1892 inclusive.
yes,
So this is setting out, you agree, what the arbitrators, the Dominion provincial arbitrators, as you've referred to them, they are to do. Isn't that right?
that's right.
Okay. And then as you-
Sorry, and what does 4 say?
all the accounts referred to in this agreement
So,
shall be
but what's
brought
it
down-
saying?
Oh,
That,
excuse me.
that the claims mentioned in 2D above, is that what it's saying? That the claims made in 2D above claims on behalf of Indians, or
Yes,
everything
that's how I,
shall be determined up to the end of 1892?
Is
My
that your understanding?
Is that yeah, that claims considered would be everything up to 1892 would be part of this reckoning, you might say.
Thank you.
That they would actually, do the do the accounts ultimately based upon their findings as of that date. They would, if adjustments had to be made, they would be made extended down to the 31st of December, 1892.
Thank you.
And then, of course, as we know, and you've discussed, there's a number of awards that the Dominion provincial arbitrators make. Isn't that right?
That's right.
I think they total 19 in total.
Okay.
Does that agree
Yeah.
with me? Or
Yeah. So not all of them were relevant to what I was investigating, but yes, that sounds about right.
that's a good point. Your Honor, a couple of days ago, you asked for definition of terms wherever possible. With these Dominion provincial arbitrators, I plan to refer to them by what's come to be known as award numbers,
Okay.
and I'll provide the dates wherever possible.
Helpful. Thank you.
Okay. The first one that I'd like to discuss with you is award number 3.
Yes.
Now, we looked at this, or you looked at this with my friend. That's the first decision of the Dominion provincial arbitrators dealing exclusively with Robinson Treaty matters. Isn't that right?
That's right.
Okay. And it's found at tab 16 of our compendium. Portions of it will look familiar, I'm sure, because we have been discussing it over the last few days. Now, just to recap then this, if we look at page 289 in particular, highlighted there, scroll down a little bit. This is the paragraph 4 and in paragraph 6 that in particular has been brought to the court's attention, right?
Yes.
And I should just go back and mention award number 3 is dated the 13th February 1895.
Yes.
So here we have an award, you've told us, specific to the Robinson Treaty annuities.
Yes.
And in particular, this is about the responsibility for paying increased annuities.
Increased annuities and arrears of increased annuities.
Yes. But only because there was never any issue, of course, that the base annuities had not been paid consistently.
It was understood that they had been paid consistently. Yes.
Okay.
Yeah.
And of course, we know from your testimony to date that the arbitrators in award number 3, they dealt with pre-Confederation liability different than post-Confederation liability.
They did.
Paragraph 4 that we've looked at dealt with pre,
Yes.
and paragraph 6 dealt with post.
Correct.
Okay. We've already looked at paragraph 4 today. I don't propose we go through it again. Paragraph 6 has been looked at as well. That is the paragraph that the Dominion provincial arbitrators said that the ceded territory mentioned, the Robinson Treaty territories,
Yes.
became the property of Ontario under the 109th section of the British North America Act 1867, subject to a trust to pay the increased annuities on the happening after the Union, that's Confederation,
Yes.
of the event on which such payment depended, and to the interest of the Indians therein to be so paid. That the
Yes.
ultimate burden of making provision for the payment of the increased annuities in question in such an event falls upon the province of Ontario, and that this burden has not been in any way affected or discharged. Correct?
Yeah, so we have in section 4, the pre-Confederation annuities were under, paragraph 4, I should say, understood to be a section 111 debt, and the post-Confederation annuities, increased annuities, I should say, I'm sorry, increased annuities, and the post-Confederation increased annuities in section 6 are understood to be a section 109 trust. Yes, that's correct.
Thank you. Okay. Now, this Canada and Quebec, of course, had both argued that Ontario was responsible under section 109, isn't that right?
In the,
Award number 3.
okay, I would have to review their particular arguments. I don't know if that's, yeah, I believe that is true. I have some points of their submission. Well, certainly, yes, I have Robinson, confusingly, for the Dominion, agreeing with Quebec's argument that it was indeed a section 109 obligation.
And in fact, we see here
Sorry.
that,
I missed it.
So
Canada and Quebec argued that.
during the submissions made,
They
Sure.
argued that.
that the post-Confederation increased annuities should be, sorry, I'm just going to see here. A section, Quebec argued that they should have been a section 109 trust, and thus Ontario's responsibility alone. And Robinson for the Dominion. I guess what I'm seeing here is that he's agreeing with them about one point, which is that Robinson for the Dominion agrees with Quebec that section 142 arbitration did not relieve Ontario of any further obligations, but I'm just trying to see if the specific point that Ms. Barclay raised was also part of Quebec's, or sorry, the Dominion's argument. And
we're going to go into the transcript in a moment.
yeah,
and-
okay, yeah, I just am hesitant to attribute arguments to people without having yet.
Just like to remind the witness that you can also look at your report, not
Of course.
just.
Yes, of course, yeah, that would be probably more helpful, yeah. Yeah, a moment to do that.
Is that too noisy?
Not for me.
Professor Messamore, if it's not jumping out at you, I'm
Yeah, I just,
content to rephrase my question and
Mhm.
to come back to it perhaps when we go into the transcript. It's a very long
It
transcript.
is a
you'll
very,
remember.
what is 500 pages, I think. And
503 if
so
I
I've,
recall.
I've boiled down some points in my report, but your
Okay.
question kind of turned on a subtler point, and I was just trying to determine what
Okay,
Robinson for the Dominion actually was agreeing with Quebec about, and I think
So-
it, yeah, sorry.
so you agree with me, certainly, I think, that this decision of the arbitrators of 109, that was certainly what Quebec had argued before the 1870 arbitration.
Yeah, that's certainly true, and I think, yes, that was their position.
And then one of the things that you pointed out, actually, maybe we can turn up slide 210. Meant to take you to this when we were talking about the statute that created the Dominion Provincial Arbitrators.
Yes,
So here you've just listed out, in fact, who they were.
yes.
Can you tell us who the Dominion Provincial Arbitrators were?
I'm sorry, the Dominion provincial.
The Dominion Provincial Arbitrators at slide
Okay.
210.
For the Dominion, the Honorable George Wheelock Burbage.
Okay,
Oh, and sorry, I thought you meant for the Dominion. For Ontario, the Honorable John Alexander Boyd. And for Quebec, the Honorable Louis Napoleon Casson.
and then can you tell us what you say about Casso here?
Yes, I said that he was counsel to Quebec at the time of the Section 142 arbitration.
And in fact, we saw that it was he who was making the argument about section 109, isn't that right?
At the time of the,
1870 arbitration.
that's correct.
And in fact, you point out a page, I think it's 187 of your report. You say Justice Casso's opinion on award number 3 was consistent with the position he took on behalf of Quebec in the 1870 arbitration. Do you remember that?
Yes, I do.
And just still on slide 210, you agree with me that the Honorable George Wheelock Burbage of Ottawa, he was at one time the Deputy Minister of Justice for Canada?
Yes,
And we saw his name already today, didn't we?
yes, we did.
He attended the meetings in October 1884 when they were discussing liability for the increased annuities,
Yes, when they were discussing general settlement of accounts, yes,
including the liability for Indian annuities.
correct.
Thank you. Okay. So in your report and in your testimony, you spent quite a bit of time talking about the arbitration decision. You agree, is it fair to say, with the decision of the Dominion Provincial Arbitrators in paragraph 6?
I'm sorry,
Paragraph 6 of the Dominion Provincial Arbitration Award number 3,
yes,
assigning liability for post-Confederation increased annuities to the province because of section 109.
province of Ontario.
Province
because
of Ontario.
109. Yes,
You agree with that decision? You said in your closing remarks that you thought that what was fair.
what I said, as I recall, I mean, it's not for me to determine whether it's fair or not. What I said is that I understood the rationale for that decision. And what I meant by that is they believed that the responsibility lay with Ontario. And the only way it seemed to practically achieve that, because they could not go back and reopen the Section 142 arbitration, the only way to practically achieve that was to describe the post-Confederation obligation for increased annuities as a Section 109 trust, or at least that's what they saw as a practical way to do it. That was what I meant to convey. So, I obviously was asked as my opinion for as an expert witness where I felt that the responsibility lay. And in that part of the report, I was trying to understand the process of this decision and why they felt locked into it. And I mean, if you're asking me my view in general, I have said that my contention would be that responsibility has to be assigned, that it would be with the province of Ontario for increased post-Confederation annuities.
I believe you said that justice would dictate that so that Quebec would not be responsible.
Yes, yes,
And of course, that's not your legal opinion, that's your layperson's opinion.
exactly.
But of course, as you've acknowledged, that section of award number 3, that finding in paragraph 6, that was appealed by Ontario successfully to the Supreme Court, right?
That's correct.
And the majority overturned that decision.
Yes,
They found that section 109 does not apply.
they did.
The JCPC, the Judicial Committee of the Privy Council, it upheld that Supreme Court of Canada's decision, didn't it?
Yes, it did.
And you agree, I'm sure as well, that in Chief Justice of Canada Strong's decision of the majority, he substituted the language for paragraph 6. Do you recall that?
Yes, yes.
I'd like to look at that. That's at tab 17.
I'm just going to look at the part of my report that, or part of my, okay, yes, I see that. Yeah. Tab 17.
Tab 17 is the version of the Supreme Court of Canada decision that you have in your, same as anybody's, but it's. And if we look at page 298 of the compendium, page 508 on the left-hand side of the Supreme Court of Canada reported decision.
Sorry, what did you say? 298?
298 of the compendium, Your Honor.
Thank you.
Page 508 of the decision itself. Are you there? Mr. Messamore, are you there?
Yeah, I like to flip back to see who these comments are being attributed to. So,
Well, the convenient thing
oh yeah,
about
the
the
Chief
Supreme Court of
Justice
Canada
starts-
reports is that it actually says on the side marginal notes
Ah.
that this is the Chief Justice. You see that?
so it does, yeah.
So here we have at the conclusion of his reasons for judgment. Speaking of the paragraph that begins, this appeal must be allowed. This appeal must be allowed, and the award must be varied by substituting for the 6th paragraph thereof the following. The ceded territory mentioned became the property of Ontario under the 109th section of the British North America Act 1867, absolutely and free from any trust, charge, or lien in respect of any of the annuities, as well those presently payable as those deferred, and agreed to be paid in augmentation of the original annuities upon the condition in the treaties mentioned.
Yes.
He goes on and he says, and further, by striking out the 7th and 9th paragraphs of the award. Just dealing with that last sentence, reading award number 3, the 7th and 9th paragraphs, those sort of dealt with interest that would be due if Ontario had the responsibility under section 109. You remember that?
Yes, I do.
So what the Chief Justice, I think you'll agree with me, is these are incidental that must fall if the finding of paragraph 6 falls. Is that
Yes, they
correct?
go together. Yeah.
Thank you. So he's speaking about the post-Confederation liability annuities here, the liability rather for post-Confederation annuities in paragraph 6.
For post-Confederation annuities up to the level that's been under discussion, up to $4 per person.
Well, he doesn't say $4 per person, does he?
No, I think to me, though, the context again, and this is sort of historical thinking, I think, when you think about the arbitration process in general, the Dominion provincial arbitration, that was in the context of considering increased annuities to the level of $4.
Well, we're going to look at the transcripts, but I put to you that he does not restrict that. He says in respect of any of the annuities, as well of those presently payable as those deferred, and agreed to be paid in augmentation of the original annuities upon the condition in the treaties mentioned.
Yeah.
Those are his words.
Yeah, I mean, this I think would be more of a legal question as far as the words of the Chief Justice.
Well-
But my point as a historian is that the Dominion provincial arbitration concerned discussion of annuities to the level of $4. We'll remember that Van Coonet, before that process, dared to raise the question about the clause about such further sum, and was told, you know, you're past it, we want you to retire at age 56. And they seem to be quite dismissive of the idea of opening it up to any further discussion. And so my thinking is that this, again, this is an interpretation, a historical interpretation.
When you
that-
say this,
I'm sorry,
yours?
the limit, the discussion of the annuities in the Dominion provincial arbitration, my historical opinion, yes, is that that discussion was only ever limited to augmentation of annuities up to $4 per person.
We'll come to Mr. Van Coonet's letter and other incidents where it's quite clear, I think, that the Dominion actors are aware that further money could be paid.
Yes, I
But-
would accept that they're aware of it. Yes, the treaty itself was read, so they could hardly be unaware of it. And yet recurred throughout that transcript, we hear again and again the phrase not to exceed $4 without the qualification. And there isn't a lot of discussion about what might happen if amounts beyond that were
Well,
considered.
As we've both agreed, that transcript is long.
Yes,
There's
yes,
lots discussed in it. We'll go into it in a bit,
of
but
course.
for this decision,
Mhm.
the Chief Justice of Canada is
Mhm.
forming the majority decision,
Mhm.
overturning the Dominion provincial arbitrators on the point of 109. You agree with me that he uses the language, any of the annuities?
Yeah, I mean, his point is that 109 does not apply, I think, and I don't really want to go beyond that into matching my legal mind against that of the Chief Justice. Shall we put it that way?
Ms. Evans was on her feet, not sure. if
I
it's
just
still on.
wanted to say that Professor Messamore had already answered the same question.
Well, Professor Messamore has also suggested that somehow this passage is restricted to $4 augmented annuities. And I'm asking her to agree with me that in fact, those words in the Chief Justice decision do not specify that. I think you'll agree with me on that?
In fact, I think that's the question.
Do you say you've answered it?
I think I have in saying that I cannot perhaps answer it in the sense of a legal analysis of what a ruling by the Chief Justice means.
Can we turn to your report at page 195, please? Sorry, a moment to find my own place. Okay, at the bottom, well, the problem is that I have a different copy of your report before the title of the table of contents was put in it. I'm looking at a paragraph that begins, in considering the questions presented by Ontario's appeal. That's at the top of your page.
Okay,
Sorry. Page
I'm-
195 of the report.
Yes, Your Honor.
Okay. Okay, I've got it. Thank you.
Do you have it? You write, in considering the questions presented by Ontario's appeal of the 1895 Dominion Provincial Arbitration, Chief Justice Strong rejected the idea that the obligation to pay the annuities represented a charge or lien upon the surrendered lands. There was no indication that any increased annuities, and then you begin a quote, were to be paid out of the proceeds of the lands or out of any particular fund, end quote, he asserted. The increase was not designated, quote, to be paid out of the proceeds of the land, but has reference only to the event in which the increase was to become payable. You see that?
I do.
Then I want to look at page 503 of the decision itself. We're back to tab 17, Professor Messamore. And if you might turn up page 503.
Yes.
I think this is where you were excerpting portion of Chief Justice Strong's decision. So I'd like to read this portion out that's highlighted, then I have some questions for you about it. Chief Justice Strong says, in the first place, nothing in the clause of the treaties providing for the augmentation of the annuities in the event specified indicates that the undertaking to make these increased payments was to constitute them a charge or lien upon the surrendered lands. There is nothing showing that either the original annuities of £600 and £500 per annum, or $1.60 per head of the respective bands of Indians, were to be paid out of the proceeds of the lands or out of any particular fund, nor that in the event of a right to the increased amount arising, it should be paid out of any particular fund. All that is specified is that in the event of the augmentations being payable without loss, they were to be paid. This does not mean that the increase was to be paid out of the proceeds of the lands, but has reference only to the event in which the increase was to become payable. There is therefore no ground for saying that there was any express charge, lien, or trust. You see that?
Yes, I do.
So do you agree with me that he is speaking about augmented annuities and also pre-augmented ones here? The original and the increased.
Yeah, I think, yes, I think what he's doing is rejecting the idea that any payment was coming, a section 109 obligation. And there was discussion among the justices in this about whether there was a particular fund from which annuities would be paid. I think just as a general question.
Right.
yeah.
Thank you. And the event that the Chief Justice, the phrase he uses, the event specified, do you agree with me that he's speaking about if the event specified is if annuities could be increased without incurring loss?
Yes, I think that's fair to say.
And would it be fair to say to you that he saw that event as being a condition precedent or a trigger?
Yeah, I think that's a good way to think of it.
And you said before, of course, that Chief Justice Strong and the Supreme Court of Canada appeal could only be taken on a question of law from the arbitrators, isn't that right?
That's right. Yeah.
Okay. And then,
That's often a debate amongst
Yeah.
people trained in the law.
fair enough. I was confused by the space given to it in the report, so I wondered if there was a disagreement, but I don't think it, I don't think we're
guess
disagreeing.
the space given in the report may reflect the fact that it's a 500-page transcript, and so I felt that it was important to boil it down as much as possible, but it does, I will consume a lot of space in the report because it was a long document, yes.
And that was the only reason I raised it.
Okay.
If there was a disagreement about us on that, we would
Okay.
have some further questions, but it
Yeah, I
doesn't
mean,
sound
as I
like-
saw it, that part of my report was about summarizing the ideas expressed by the Chief Justice, or by the justices, including the Chief Justice.
And then you say also at page 196 of your report, we could turn to that. At the top of page 196 of exhibit 78. It's on the screen as well.
Yes.
This is in the context of speaking about, I believe, the arbitrators could be appealed on questions of law. You say, the result, he said, you're speaking there of the Chief Justice?
Yes, I am.
Was that quoting from the Chief Justice?
Yes.
The liability incurred by the Crown and the province of Canada to pay the increased annuities was at the time of Confederation a general debt or liability of that province within the meaning of the British North America Act, end quote. Handled in the same manner as other debts that is assumed by the Dominion government, subject to the debt allowance limits. Go on and you conclude that paragraph. He acknowledged that it was a debt not based on past expenditure, but for future payments.
Yes.
And that's a bit of that quote is a bit of a paraphrase, I think.
Yes.
While you have it in quotation marks, in fact, Chief Justice Strong talks about within the meaning of the 111th section of the British North America Act. We can look at that at 506.
506.
Sorry, of tab
for us,
17,
That would be page 296, I think.
297, Professor.
297, okay.
And
So
in the
page-
first full paragraph of this left-hand column of page 506. paragraph that begins the result. Is that the liability? Do you see that?
Yes, I see that.
So he says, and this is
Yeah.
almost
Yep.
verbatim what you say, but he
Yep.
inserts into that quote that you excerpted within the meaning of the 111th
Ah.
section of the British North America Act. Do you agree with me?
Yes, so that was,
Sorry, I missed what you're looking at.
Of course, Your Honor. I'm at page 297 of volume 2 of our compendium behind tab 17.
Oh, you're going to the actual
I'm
decision.
going to the actual Supreme Court of Canada decision.
Mhm.
yes, so, yeah, I would accept that in that, making that quotation, I have erred in not including, I've missed the clause that says the 111th section. So, I mean, I don't know that there's a difference, but yes, I would acknowledge that's an error. That should have been quoted verbatim.
Thank you.
And now I just have to find that on 297. Left or right column. Is it here?
On the left-hand column of 297 of the compendium, the first full paragraph that begins the result.
Thank you.
And I was just pointing out that
I see it.
Justice Strong, Chief Justice Strong, it's very clear that he is attaching this to the 111th section of the British North America Act.
He is attaching this, his decision.
Yes, he's saying that the
interpretation.
liability incurred to pay the increased annuities fell within the meaning of the 111th section of the British North America Act. And Professor Messamore is just acknowledging that that 111th section didn't make its way into her report.
Yeah, so it said, my part of the quoted passage says general debt or liability of that province within the meaning of the British North America Act, which of course is the 111th section, but I left out in making that quotation, should have quoted it verbatim and specified within the 111th section, which of course deals with debts and liabilities.
This is a fine point, but to be clear, I think it is a verbatim quote. It's just you haven't included ellipses.
Well,
so
that's
you pick it
exactly,
up
I'm
first.
sorry, yes, but yeah, that's what I meant by
There's
not.
nothing suggesting in
Yeah.
Dr. Messamore's report that words are missing.
Yes, that's right. That's fair to say. Yeah, I would have, I mean, yeah, I would just describe it as an error and not specifying that, yeah.
Thank you.
Then if we look at page 196 of your report, Professor,
Yeah, same page, yeah.
same page, different page for me, excuse me.
Oh, is it? Okay.
Mine is so heavily highlighted
Hmm.
in different colors that made sense at the time. It takes me a minute. So I'm at the section that begins with the paragraph, Strong appeared to recognize. You
Yes,
see that?
yes, I do.
You say, Strong appeared to recognize that in many respects, the crux of the matter lay in the 1870 award apportioning debts and assets. Then you quote from Chief Justice Strong, we are not at liberty to unravel the arrangements between the two divisions of the old province, upon which it may be assumed the provisions of the Union Act as to the apportionment of assets and liabilities was based in order to arrive at some secondary meaning contrary to the ordinary and natural import of the language of the Act. Do you see that?
Yes, I do.
Now, you suggest there, of course, that there's a crux and that the crux is that Chief Justice Strong is saying he's limited or restrained by the 1870 award. Do I have your evidence right in that?
Yes, I think that's broadly true.
I'm going to suggest to you that in fact, in this paragraph, he's speaking about the arrangements that had been negotiated and enacted in the Union Act, the British North America Act. Would you agree with me on that?
Yes.
Now, he does ultimately turn his mind to the 1870 award. If we look at the compendium at the bottom of 297 on the left-hand side, there's a paragraph that says, then turning to the award of 1870. Do you see that?
Yeah, sorry.
I'm at tab
Um,
17, Professor Messamore, page 297.
Page 297, and.
I'm on
so
the
what is
bottom left
phrase?
side.
Yep, bottom left. And what is the start of the sentence in question?
The last paragraph that begins in the left-hand column.
Oh, then turning to the award of 1870, yes, okay.
So this paragraph follows the paragraph about which we just discussed. He was talking about 111.
Yes,
And now he's turning his mind, I would suggest you, to the award of 1870.
yes. Dealing with section 142.
Yes.
Yeah.
And at this point, he's now referring to the liability of augmentations. And then if we look back to your report at page 196, I think this is where you talk about that portion of his opinion.
Mhm.
There's a paragraph that begins, he acknowledged. Do you see that? It's on the
Yes,
screen,
yes, I do, on my report, yes.
right there.
Yeah.
He, Chief Justice Strong, acknowledged that the need to pay increased annuities had been unknown at the time of the 1870 award. And then you begin a quote from him, but this, in my opinion, can make no difference. There is nothing before us to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made their award.
Yes,
And then you go on to say, it's tempting to add that there's nothing to show that they did have such an intention. Do you see that?
yes, I do.
I want to ask
Yeah.
you some questions about that.
Okay.
Now, you agree with me that the Chief Justice said that the arbitrators had the treaties, the Robinson treaties before them?
Well, I don't know specifically that they did. Yeah, I guess I would have to say I don't know. I mean, I would have assumed so if they're considering these obligations, but I don't actually know that with certainty.
Okay, but you've read the decision, of course, of Chief Justice Strong.
Yes, yes.
Okay. So let's look at the entire passage from Chief Justice Strong's reasons, and I'm at tab 17 still. And I'm going to begin at page 297. And I'm on the right-hand column now.
Mhm.
And realizing this is entirely highlighted, I don't need it all, so just give me a moment. Okay. I'm going to begin 6 lines down. The end of that line begins it. And he says, it is true. Do you see that?
Yes, I do.
Okay, I'm going to read along there. Your Honor, do you have that point?
Yes, I do.
It is true that at the time this award of 1870 was made, no question had arisen regarding the payment of the augmented annuities. But this, in my opinion, can make no difference.
Yes.
There is nothing before us to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made their award. Do you see that?
Yes, I do.
You agree with me that you didn't include that section in your report?
I'm sorry. No, I did.
That particular section
Uh,
where there's nothing to show that they didn't
Yes,
intend to
yes, I did.
include the
Yeah,
increased annuities?
yeah, it's in my report.
Okay, where?
Page 196, right in the middle. There is nothing before us to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made the reward. Is that what you mean?
Yes, thank you. And then when you say at that same paragraph you've read that Chief Justice Strong acknowledged that the need to pay increased annuities had been unknown, do you agree with me that the Chief Justice is saying that the question had not yet arisen?
Yes.
And then if we look still back at the Chief Justice decision, from where I left off, he continues, and he's speaking here about the increased annuities. He says that liability was clearly within the terms of the 142nd section of the British North America Act and the reference to them. You see that portion?
Yes, I do.
Can I
Can-
just go back, please? The question you put to the witness was, do you agree that the Chief Justice is saying that the question had not yet arisen? And you're both talking about the question of increased annuities?
Yeah,
Yes.
the
Okay.
phrase that Professor Messamore had said in her report was the need to pay wasn't before them. And Chief Justice Strong, I put to her, said that the question had not yet arisen. There wasn't any augmented annuities yet in 1870. And then picking back up, he says they had, the arbitrators in section 142, had power to decide questions of law, as well as questions of account and matters of fact, and were the sovereign judges of all such questions. It must therefore be intended that having before them the treaties and the Act of Parliament under which they acted, that would be the British North America Act,
Yes, section 142.
they decided as a question of law that the increased annuities were not charged upon the surrendered lands and that there was no trust of these lands for the purpose of paying the annuities. You agree with that?
That's what he says, yes.
Okay.
And I'm sorry, but I'm looking for that section that
Certainly.
you just read.
Yes. So I am at tab 17, page 297,
Yes,
and I'm reading from page 507 of the Chief Justice's reasons at the right-hand column of the page.
yes.
And where about halfway down, he says that liability was clearly within the terms,
And the line begins,
their award. End of the sentence before. Gaji, are you able to sort of move your
Got it.
cursor, perhaps?
thank you.
Do you have that?
Yeah.
So just to then reiterate,
Mhm.
if you lost us, Your Honor, while you were trying to find the pinpoint, he's Chief Justice Strong, Professor Messamore, he's speaking about what the 1870 arbitrators did.
Yes,
And he says that while no question had arisen yet about the payment of augmented annuities, he goes on to say that there's nothing before us, the Supreme Court, to show that the arbitrators of 1870 did not intend to refer to the liability to pay the increased annuities when they made their award, when they made the 1870 award, right?
you're asking me if that's what he's saying.
That's what it
That-
says.
that's what
I
he's
haven't
saying.
misread it.
Yes, yes, of
Okay.
course, yeah.
And then he goes on, we've just discussed that he goes on to say the liability was clearly within the terms of the 142nd section of the British North America Act and the reference to them.
Yes.
Chief Justice Strong, would you agree with me, is expressing that the arbitrators had that jurisdiction to determine the issues that the treaty might have raised and how to divide it between the UPC? Is that right?
I'm sorry, you're asking me if that is his view?
That's just Chief Justice Strong's view, yes.
Yes.
And then he also said that the treaties were in front of them.
Yes, he does.
Okay, so you weren't sure about that. I'd suggest to you, would
Yeah.
you agree with me that Chief Justice Strong certainly thought they had the treaties before them to determine their decision?
Yes, I recall that he had said that. Yeah. Yeah, I mean, I guess not to doubt the Chief Justice, but you know, when I considered the arbitration, I didn't specifically know whether they had the treaties before them or not.
And then he says that three lines from the bottom, on the right-hand side, he begins the sentence, "The arbitrators," do you see that?
Yes.
The arbitrators, are you there, Your Honor?
Thank you.
The arbitrators must therefore be taken to have had in mind all the annuities, the original fixed annuities, as well as those contingently provided for. They, the arbitrators, held that the lands vested absolutely free from any charge, and this must have included both. Agree with me on that?
Do I agree that that's what he said?
That's what he says.
That's what he says. Yeah.
And when he
Um,
says
mhm.
they've included both, he's of course referring to what he just talked about. The original annuities, as he put it, and those contingently provided for, right?
Yeah. And so my concern, I suppose, with that is that they capitalized a fixed amount to provide for
The
the
original.
annuities as they then existed. Yes, the original annuities. And so to me, that implies, because of course they would not have, the arbitrators of section 142 could have no way of knowing what amount might ultimately be due. It was impossible for them to capitalize it. And as we've established, the general acknowledgement of a claim to increased annuities did not come until later, till about 1874, I guess, or three.
Chief Justice Strong, when he speaks about the original annuities, he's speaking about the base annuities.
The base annuities, yes.
And when he speaks about the annuities contingently provided for, he's referring to the possibility of an increase.
I think he's referring to the possibility of an increase up to $4 per person, yes.
Well, again, we'll
Yeah.
have to disagree on that point. He doesn't say that, does he?
Well, he said provided for, and what was provided for was $4 per person, isn't that right?
What was also provided for was, as you pointed out many times, further increases without incurring loss. Isn't that right?
I would not be able to interpret what he means by this, but I would come back to the point that discussion had been about annuities augmented to $4 per person. It had not been about anything else beyond
Professor.
that. Yep.
Professor Messamore, you agree with me that the clause in the treaty has a contingency in it that if the revenues are such to allow an increase without incurring loss, such further sums may be graciously pleased to order. Is that right?
Yeah, so there's the phrase, I mean, again, this is not my field to analyze, I think.
Excuse me, I'm standing up.
Oh, I missed that.
Yeah, my friend is putting to the witness an interpretation of the treaty that has been rejected by this court and by the Court of Appeal. And I don't see any value in putting it that way unless it's put in the context of a question about what people, some actors may have believed in 1875. Because my friend is speaking about what the treaty says, and if she should distinguish between what the court's already determined the treaty says, or if she wants to confine her comments to what some actors may have believed, that's okay. But I don't think it's fair to muddy the waters about what the court's already ordered or decided.
I may respond? Ms. Evans on this?
Ms. Evans wants to jump in, then you should respond to both. Go ahead.
I also think that this line of questioning is really helpful. I personally think it's very helpful to review this decision of the Supreme Court. And so I haven't objected so far to the idea of going over these points again. This is a very key decision. But I don't think it's really appropriate for this witness to be providing her commentary on the meaning of what the Supreme Court is saying here. I think that's something that's going to be dealt with in argument, and that's really a decision for your honor.
But you said you thought the evidence was useful?
But I don't, I feel like this decision is absolutely useful to
Okay.
understand.
Right.
I mean, it's a Supreme Court decision. My friends have claimed that it's res judicata, so of course it's going to be an issue before your honor, and we will be making arguments.
Right.
But Professor Messamore has said many times, she's not a lawyer, and she's been very helpful in providing context. And I think in her answer, she's providing historical context about what she thinks they're talking about. But in my view, the questioning is, asking Professor Messamore to admit that isn't this what he says, it is really not helpful. That we can argue before you what it is apparent what is being said, and we can argue before you what it means from a legal.
And Ms.
My turn?
Bartley, you get to respond to both.
In Seriatim, my friend Mr. Schachter first. I actually think that I am asking questions that are consistent with both your honor and the Court of Appeals decision. I'm not suggesting that there is anything restricting to $4. In fact, I'm suggesting otherwise, that the language of the treaty provided a contingency, that if certain events happened, certain other events would happen. The first event being if the resources of the land were sufficient without incurring loss to increase annuities, that would happen. There's a contingency there. I'm suggesting that the Chief Justice just speaks about a contingency. So in response to my friend for the plaintiffs, I don't see that I'm asking anything inappropriate based on the decisions of the court to date.
That's how I understood your questions.
Thank you, Your Honor. With respect to the objection,
Go ahead.
thank you. With respect to the comments and objection by my friend for Canada, this witness, I agree. She has made perfectly clear that she's not a lawyer. I accept that. I think we all do. But she's also spent an awful lot of time, both in her report, in her demonstrative, and in her evidence, talking about how she understands this decision as a historian. And there are portions of it that I think are important to be brought to Your Honor's attention that are not in her report and we've not heard from. I'd like an opportunity to ask her about those, and I'm simply just asking her if she agrees. As she said many times, there's language without incurring loss. That's a contingency. If this is part of that.
As I understand your questions, you're asking the witness, given her opinion, you're asking the witness to agree with you that there are words and phrases in the decision that suggest that potential future increases were in the minds or in the awareness of at least the Chief Justice when the Chief Justice wrote this. And the Chief Justice is referring to what was in the minds of the arbitrators.
Well,
Do I have that? Is that what I get from your questions?
what I was asking was whether or not this contingency, I was asking her to confirm and agree with me that the contingency is broad. I heard this witness say, oh no, it's only about $4. And I'm
Right.
suggesting that this contingency that the Chief Justice is expressing and stating is in fact linked back to the words of the treaty, which goes beyond $4 as a possibility.
Right.
That's all I'm asking.
So I'm doing my best to follow, but I am leaning towards where Ms. Evans makes her objection, which is we all understand that this decision that arguments will be made on this decision. And they will be made, I am presuming, on the basis of how it should be interpreted. What the decision says, the language of the decision will be under great scrutiny. And if there is a historical reference to, for instance, what the arbitrators said, the language of the arbitration decisions will be under great scrutiny. It appears to me that some of these questions go beyond just the language of the case. I think you have scope to point out anything that the witness missed in coming to her opinion or is not taking into account in her opinion. But other than that, it's, to me, getting into submissions. So with those provisos, continue.
Thank you for your guidance. And I notice it's 12 o'clock.
Mhm.
Should we go off the record for a minute or talk about the break?
So we'll break for lunch now and resume at 1:15. Does that work? 1:15. All right. Thank you very much.
All right. Before we set until 1.